Sir, it's 6:30 with the kind permission of the Honorable Chief Justice. Can we start, sir? Can we go live? Yes. Amrit Bhargav, yeah, it's live and you can take over.
Good evening. My name is Amrit Bhargav, an advocate and alumnus of Shanmuga Arts, Sciences, Technology and Research Academy, Sastra Deemed University, Tanjavur, and it is my privilege to take you through the proceedings of today's event, being the second Sri M.K. Nambyar Memorial Lecture 2022, organized by the School of Law at Sastra University under the auspices of the Senior Advocate C.S. Vaidyanathan Chair on Law and Development. I request all of you to remain seated while I invite Ms. Shivashri Skanda Prasad, an alumna of Sastra Deemed University, to invoke the divinity in us.
Maitrim bhajata akhila hrijyetri, Maitrim bhajata akhila hrijyetri, Atmavadeva paranapi pashyata, Atmavadeva paranapi pashyata, Yuddham tyajata Spardham tyajata, Yuddham tyajata, Spardham tyajata, Tyajata pareshva kramamakramanam, Maitrim bhajata akhila hrijyetri, Janani prithvi Kamadughaste, Janani prithvi Kamadughaste, Janako devaha Sakala dayaluhu, Janako devaha Sakala dayaluhu, Damyata datta Dayadvam janata, Damyata datta Dayadvam janata, Shreyo bhuyat Sakala jananam, Shreyo bhuyat Sakala jananam, Shreyo bhuyat Sakala jananam, Shreyo bhuyat Sakala jananam.
Thank you, Shivashri. It was New Year's Day in 1898, and the Melot Tarwad at the Chemnad village, somewhere near the historic Baikal Fort, was a bus celebrating the birth of a baby who brought greatness with him. This was the great jurist, Sri Melot Krishnan Nambyar, whose life and times are being remembered today. May I request Dr. S. Vaidya Subramaniam, Vice Chancellor of Sastra Deemed University, Tanjavur, welcome the galaxy of dignitaries and the audience.
Most respected and Honorable Chief Justice of India, scholar jurists, retired Justice B.N.Srikrishna and retired Justice Santosh Hegde, revered Senior Advocate Shri K.K. Venugopal, Shastra Well-Wisher and Senior Advocate Shri C.S. Vaidyanathan, a very distinguished assembly of professionals from both the bench and the bar who are joining this event from different parts of the country, my faculty colleagues and also faculty members from different law schools and students from Shastra as well as other law schools, and all others who have gathered to be a part of this historic event this evening. It is my personal privilege to welcome all of you on behalf of the Shastra University's School of Law. It is only an event of this type can assemble gathering that is as rich and as diverse as what we see today in this online event. There are many reasons that I feel personally privileged and excited insofar as today's second MK Nambyar Memorial Lecture is concerned. But the top three reasons I would like to highlight as part of the welcome address, and I'll make it very short, beginning with the person himself in whose honor we are having this memorial lecture, the legendary jurist, Shri M.K. Nambyar, and the person who is delivering this lecture, the second M.K. Nambyar Memorial Lecture, the Honorable Chief Justice of India himself, accompanied by retired Justice Srikrishna, who kindly consented to preside over this event, and as guests of honor, retired Justice Sri Santosh Hegde and Sri K.K. Venugopal, besides our own Sri C.S. Vaidyanathan. And to all of us who are watching this event, I can only say that this event is a manifestation of over 300 years of combined judicial wisdom that is showing up in flesh and blood for this event. And I'm personally happy that we were able to get the stalwarts of the judiciary for this evening's event. The second reason is the topic itself, which the Honorable Chief Justice has carefully chosen to enlighten this audience on the development of jurisprudence post Gopalan. And very rightly so, that the topic celebrates and cerebrates the contribution of Sri M.K. Nambyar, not only in the case of A.K. Gopalan, but also in Deepchand, Golaknath, and all of them were actually the forerunners, maybe the constitutional forerunners that got intertwined in the Keshavananda Bharati, which laid down the basic structure of the constitution. So that way, the topic is another reason that we are all so happy. The third is the platform under which we are organizing this event, as already mentioned by Amrit Bhargav, under the aegis of the C.S. Vaidyanathan Chair for Law and Development, which is a reflection of the munificence that the senior advocate showed. It was just in a casual conversation that I had with him that this entire concept was midwifed and gave birth in the form of C.S. Vaidyanathan Chair for Law and Development, through which we are discharging various responsibilities as a responsible law school at Shastra, conducting various legal aid camps, and to date, we have conducted over 82 legal aid camps, which is by far the largest by any law school in the country, of which 7 of them have been directly supported ever since the inception of this chair. This chair also supports a research scholar in pursuit of a PhD. And we also have a lot of schemes that we have in mind under which this chair will be fully utilized. Friends, it is with these 3 particular reasons that I share my happiness. And in sharing my happiness, I also welcome all of you for this second M.K. Nambyar Memorial Lecture. Thank you very much.
Thank you, sir. The life of Sri M.K. Nambyar, dotted with milestones and studded with achievements, was a road well traveled, but also a road less traveled. I'm an aristocrat, part of the centuries-old landed gentry in God's own country. He dazzled as a dashing barrister from the Middle Temple. While many may find mention in history, few script history, fewer become part of remembered history, and this one personality constituted living history right from the inception of the Constitution. A lawyer of destiny was Sri M.K. Nambyar, said Sri K. Parasaran last year when the chair was inaugurated. Here again is Sri K.K. Venugopal, whose destiny's gift to India. The nation honored itself when he became Attorney General for India in 2017. And everyone remembers the broad and natural smiles from the high-ranking audience when he got up to receive the Padma Vibhushan in 2015. A generous heart that beats even today for all of his juniors and the young bar, he is stuff of legend. May I invite him to speak on the occasion?
Honorable Chief Justice of India, Justice U.U.Lalit, Justice Srikrishna, my friend Santosh Hegde, Justice Santosh Hegde, Sri Vaidyanathan, Sri Vijay Subramanian, Vice Chancellor, Shastra University, and friends. I was extremely happy to hear that the Honorable Chief Justice of India has consented to deliver today's lecture in honor of my father, M.K. Nambyar. I must mention that so far as Justice Lalit is concerned, he is a trailblazer. His thoughtful, balanced, and decisive steps have brought about a significant reform in the functioning of the Supreme Court of India in a very short span of time. The changes he has introduced have been met with overwhelming positive feedback from the bar and have gone a long way towards addressing problems which have plagued the system for decades. I'm going to take this opportunity to speak a few words about my father. Though my father was born over 120 years ago, it's a remarkable feat that his cases are still being cited on the interpretation of the Constitution and still quoted with regularity in the Supreme Court of India in regard to very other important constitutional cases which he had argued in the first 2 decades of the Constitution. He passed away in 1975. My father started his legal practice in the district headquarters in Mangalore and very soon became the public prosecutor and government leader there. At that time, there was only one post of public prosecutor and government leader. And today, of course, on account of various reasons, political and otherwise, you have 30, 40 public prosecutors and 30, 40 government leaders separately, which I think is very unfortunate. From the Mangalore official, as we call it, he went over to England, became a barrister there, who was called to the Inns of Court, did his administrative law and constitutional law masters in the London School of Economics, and came back as an advocate and continued his practice. Upon his return to India, his status as a barrister propelled him immediately to the higher echelons of legal services in Mangalore. He was offered the position, and I believe that he enjoyed his role as government counsel, but however, it was clear that he was cut for larger things. Justice Govinda Menon, he was a crown prosecutor. When he was elevated to the Madras High Court, he had a large number of cases from Kerala and Tamil Nadu, from the southern states. And he had to hand it over to somebody whom he trusted. And he knew my father, though he was practicing far away in Mangalore. And therefore, he asked my father, Nambyar, will you come over and take over my practice here in Madras? My father was only too happy to jump at that offer, and he straight away got into his car, an MDX-7. I still remember it as a small boy, even at that time. It was Hillman Meets, red in color. And he drove all the way to Madras, took over the practice, stayed in the rented house which had been rented by Justice Govinda Menon. And in Madras, he was totally unknown. But very soon, they knew that he was a public prosecutor. And the cases which were offered to him were mostly death sentence cases. And he handled them, of course, to the best of his ability. And he would even go to the high courts and argue the criminal cases. But when he was arguing one of these cases, V.G. Rao, a communist leader, and who was handling A.K. Gopalan's case, found that father was arguing intricate constitutional issues in trying to get his clients off in death sentence cases. So he went up to him and said, Nambyar, will you be prepared to appear in A.K. Gopalan's case, which was a lead case in a large number of cases and a batch. Therefore, father went over to Delhi with C.B.G. Rao. And when he went there, he was told that there are very eminent counsel like K. Munshi, etc., who had been briefed in the other cases. And they would start their argument. But Jimmy Dadachandji was the advocate on record. And he said, no, Mr. Nambyar is fully ready, he will argue. And here I have to quote from what was said by C.B. Sen. And that was, I got it written here. It was a civil rights lawyer. And Sen, this is the extract. He said, the case I remember best was the one that was heard in the very first. And B. Sen was an eminent senior advocate, and he had written this in an article. The case I remember best was one that was heard in the very first month of the court, A.K. Gopalan versus Province of Madras. The question of detention without trial was at issue, and that involved interpretation of Articles 14, 19, 21, and 22 of the Constitution. The constitutional questions raised were new, both to the judges and to the lawyers. And when M.K. Nambyar, appearing for the detainee, expounded his arguments day after day, citing case law from all over the globe, with comparisons between the Irish, and the American constitutions, the entire courtroom ceased to be completely spellbound. There were no interruptions, no questions, the all-pervading silence, broken only by the Nambyar's voice and the resulting pages of the law. Now, this, I think, is a tremendous compliment that he got from the judges who praised him in their judgment for having elucidated the intricacies of constitutional law. Because that was the very first case argued in January of 1950, after the Constitution was proclaimed. And he argued it with the Constitution alone in one hand. Though, of course, he took the aid of cases from Ireland, from the US, from England, and so on, and interpreting the Constitution. After A.K. Gopalan, there was regarded, which was a landmark case. He argued very many, very intricate questions of constitutional law, and which have been reported and are being relied upon, the principles which have been laid down in the series of cases even today. But just as in Gopalan, he had made a plea in the Golaknath case for an ideal that existed beyond the mere written words of the Constitution, when he put forward for the first time, in the case of Golaknath versus State of Punjab, the theory of the basic structure of the Constitution. As a matter of fact, there was a German author, Dieter Conrad, who had enunciated the principle of the basic structure. And I was later told that later Dieter Conrad himself had visited Madras and met my father, where they discussed the subject. MKN placed Dieter Conrad's article before the Supreme Court, argued that the amending power granted by Parliament under Article 368 of the Constitution of India was limited and could not be invoked for the purpose of changing the basic features of the Constitution. This was mentioned by Soli Sorabji in his article titled From Gopalan to Golaknath, a tribute to M.K. Nambyar. While the A.K. Gopalan case could be regarded as a start of my father's career as a constitutional lawyer, the Golaknath case was a culmination, decades of deep study of constitutional law, not just of the Indian Constitution, but of the experience of numerous other constitutions. On account of his worsening health, Golaknath was the last major case that my father could argue, signaling the end of a brilliant career. There is no doubt, therefore, that NK had an impressive impact on the legal profession. I am glad, therefore, that we are having this lecture because it has given me an opportunity personally to speak about my father and his achievements. I know that when I started my career at the bar, my father's clerk told me, please, you are asked to argue that civil revision petition, which was covered by a judgment in my favor. And I had only to go and cite the judgment to succeed in that case. And I was so nervous that I practically stammered when I told the Chief Justice, who was hearing civil revision petitions on Fridays, that this case is to be decided in my favor. But I was wondering, what would my father have felt when going from the Mofussil, as it were, that's what the districts are called, to Madras, the presidency capital, and from there to Delhi to argue the A.K. Gopalan's case. But he did it extremely well. And as you saw from that extract, he did it very well indeed. Therefore, I would end by saying, quoting Ernest Hemingway, I had an inheritance from my father. It was the moon and the sun. And though I roam all over the world, the spending of it, that inheritance, it is never done. Thank you very much indeed.
Thank you, sir, for that anecdotal address about this champion of fundamental rights. The memory of Sri M.K. Nambyar, everlasting and evergreen, stirs us to the keen feelings of reverential nostalgia. For today's event, it is my privilege to say a few words in the honor of Justice Nitya Santosh Hegde, who needs no introduction. A distinguished counsel who served as Solicitor General for India between 1989-1990 and from 1998-1999, was directly elevated to the Supreme Court in 1999 and retired in 2005. Famed for his role as Karnataka Lokayukta, he represents the conscience of this country's crusade against institutional corruption. Last but surely not the least, he is a great son of a great father. This is Kaudur Sadananda Hegde, a multi-dimensional personality who literally embodied the sense of constitutionalism with remarkable grit. May I request Justice Santosh Hegde to say a few words.
Sir, may I request, please unmute, sir. Yeah.
It's unmuted.
Okay, can you hear me? All right. Honorable Chief Justice of India, Justice sorry, Justice U.U.Lalit, I'm extremely sorry. The presiding justice of this proceeding, this meeting, Justice B.N.Srikrishna, immediate past Attorney General of India, Shri K.K. Venugopal, Senior Advocate Shri Vaidyanathan, Dr. Vice Chancellor Dr. S. Vaidya Subramaniam, Mr. Senior Advocate Amit Bhargava, Ms. Shivasini Skandaprasad, and all the participants in these proceedings. I deem it an honor to be invited to participate in these proceedings today. It was a wonderful experience for me because of the fact that when Mr. Nambyar was MK Nambyar was practicing in Mangalore, he was the topmost member of the bar at that point of time, respected by everybody as a senior to them. So was the feeling of my father. It was a rare privilege, I was told, that to occupy the post of a government pleader and public prosecutor, which he very effectively and successfully discharged his duties. And I'm told in 1948, when I was 8 years old, he shifted to Madras, and thereafter his practice is very well known. Everybody knows about A.K. Gopalan's case and other things. But what I came to know from my father was that my father himself came from a very small place to practice in Mangalore, and he admired Mr. M.K. Nambyar so much, and he used to say to everybody, I can only justify the post he was holding after Mr. M.K. Nambyar demitted that office of government pleader and public prosecutor of Dakshina Kannada at that point of time and all. So my father was full of praise for him, and when he demitted office from the Supreme Court, Mr. M.K. Nambyar wrote a letter. He had just returned from a trip to Switzerland, I'm told, and my father had retained that letter right through his life and all, and in which Mr. Nambyar very praised my father for demitting the office at the right time. It wrote to my father. But be that as it may, now after I joined the bar, like any one of you, I've also read about the A.K. Gopalan's case and many other cases which Mr. M.K. Nambyar argued. It is a great thing to be a leader of the bar in an official court, then move over to the state capital just soon after the independence. And after the constitution was enacted and accepted by the country, a person to become a top constitutional lawyer of the country itself is a great, great achievement. And I congratulate and thank Mr. C.S. Vaidyanathan for naming the chair after him, and these lectures are after him, and providing a idea to the future lawyers what Mr. M.K. Nambyar was and what they should emulate in their professional life from Mr. M.K. Nambyar's lifestyle. I don't have much to say because Mr. Venugopal has already said much about things which I was about to speak, thereafter, all of you will know what to say about his lawyer as a constitutional expert and all. I thank the organizers for giving him this opportunity of participating in this program, and thank you all. Once again, thank you very much.
Thank you, sir. Truly a tryst of coincidence from two eminent Mangaloreans, one living and one watching from above. A man for all seasons, Justice Bellur Narayanaswamy Srikrishna, the scholar and polymath with unmatched mastery over all the subjects that he has literally reigned. A jewel from the Bombay bar, he represents all that is great about India: heritage, composite pluralism, and intellectualism. No stranger to Shastra deemed university, his 2016 visit will be remembered for the great lecture and the fine evening of conversation on some fascinating anecdotes from good old Bombay. Elevated to the Supreme Court in 2002, retired in 2006, trailblazing a number of judgments. May I invite him to deliver the presidential address.
Thank you, Amrit. The Honorable Chief Justice of India, Justice Lalit, my brother Santosh Hegde, my good friend Mr. Venugopal, Mr. Vaidyanathan, Senior Advocate, and of course, Dr. Vaidya Subramaniam, the Vice Chancellor of Shastra University, and the gracious lady who sang for us the memorable composition of the great Kanchi Paramya seer, Shivasri. It's indeed a privilege for me to be asked to preside over this pleasant function, which is to be addressed by the Honorable Chief Justice of India. Now, every one of the speakers had something to say about his father and his connection with Mr. Nambyar. Let me begin by saying my only memory of Mr. Nambyar, late Mr. Nambyar, was I was just recruited into the bar in the Bombay bar. And I remember in room number 49, arguing a matter sitting in the chair. My first glance was a sense of disbelief. So my father was a senior advocate in the Bombay bar. So I turned to him and said, how is this that this gentleman is allowed to address the court sitting on the chair? He told me that he is a very senior constitutional lawyer who has come here to address constitutional issue to the bar. And he was, I think it was one of his last few appearances in court, and he was not very well at that time. And an extraordinary privilege was given to him to address the bench by sitting while making his address. He also did something interesting. After his arguments were over and we were getting out of the courtroom, he introduced me to Mr. Nambyar and said, Mr. Nambyar is a barrister from the temples of England, while we are all from the temples of Matunga. I distinctly remember that a quip that he made. Apart from that, the greatness of Mr. Nambyar is known right from A.K. Gopalan to constitute the Golaknath case, where he planted the seed of this constitutional doctrine, which has really saved this country from going haywire, from turning into an autocratic, dictatorial entity, a politburo, instead of being a democratic institution. That he was a great constitutional lawyer is something that we have learned. Though I must say, I confess, I didn't understand what he argued in those days, at least later on when I read the judgments that were there from K.K. Gopalan downwards, that he was a great architect of the Constitution. He was one of those who chiseled the fine features of our Constitution that we see today. The great thing about our Constitution is, and I must say, the great thing about our Honorable Supreme Court is that there are, if you look at the Constitution, Article 19 doesn't even talk of the right to education. There are plenty of unenumerated fundamental rights, which the Supreme Court has, on account of its legal ingenuity, used its ingenuity in extracting from Article 21 several fundamental rights which are essential for a dignified human life. Right to education, of course, must be necessarily at the top, as we saw in the judgment of the Supreme Court, which resulted in Article 51A. Now, education is something very interesting. Right to education, does it mean merely the 3 R's, read, write, and arithmetic, or does it mean something more than that? I remember as a young student in the university, I used to see a placard in which it was written, Sa Vidya Ya Vimuktaye. I didn't understand much in those days, although I did understand the meaning of the words, that it meant that education is that which leads to liberation. Now, at the age of 81, after having seen all that has been happening around, it appears to me that this liberation is not merely a philosophical liberation, sociological liberation also. We must liberate ourselves from our passions, from our tendency to do violence, from our tendency to cheat, tendency to become corrupt, tendency to inflict violence on our neighbors, tendency to be intolerant. This is liberation, that is real education. And if every human being aspires for this education, so be it. It should be our obligation to give such education to every young man, young mind that aspires for this kind of education. That this has been chosen as the topic of today's talk by the Honorable Chief Justice is a great tribute to the Shastra University and its Vice Chancellor and all the persons that be in its advisory board. It is essential that while we advocate the right to have education, we must also ensure that there is an obligation to educate properly. with these few words, I am also eager to understand the facets of education on which the Honorable Chief Justice is going to illuminate us with his lecture. My congratulations, felicitations to both the Honorable Chief Justice and to Shastra University for organizing this pleasant function and inviting me to be a participant in it. Thank you very much, Mr. Amrit Bhargav. Nice to see you again after a long time. Over to you.
Thank you, sir. You can see the light of judicial independence glistening in your eyes. And thank you for reinforcing our faith in our constitution, a living document for this nation. Remembering Sri M.K. Nambyar sets us on a whirlwind of memories until his departure in 1975. A larger-than-life personality, he was largely instrumental in the growth of fundamental rights jurisprudence and in many ways breathes the elixir of life into constitutionalism as it is spoken of today. On this special evening, the presence of His Lordship Justice U.U.Lalit, Chief Justice of India, has inspired many a mind and gladdened many a heart. It is my singular honor to say a few lines in the honor of your Lordship. Justice Uday Umesh Lalit comes with a treasure of experience from the Bombay and Delhi Bar, having been designated as a senior counsel by the Supreme Court in 2004. Appearing in a vast range of sensitive matters, His Lordship won praise for the breadth of preparation and presentation and was eventually directly elevated as Judge of the Supreme Court of India in 2014 as a mark of great recognition. He was sworn in as the 49th Chief Justice of India on the 27th of August 2022. Posterity will record that His Lordship is only the second directly elevated judge from the bar to reach this high constitutional office after Justice Sarvmitar Sikri. A tenure well remembered for various judgments, his transformational reforms in starting live streaming of court proceedings took the access of justice to stratospheric levels of observation. In all of His Lordship's judgments, what stands out is not just the justice of the law, the justice of the spirit, but justice from the heart. Truly, like Justice P.V. Rajamannar, said of Justice Lionel Leach here in the Madras High Court long ago, His Lordship too is every inch a Chief Justice. His Lordship will be remembered for a long time indeed. And may I humbly request your Lordship to deliver the second M.K. Nambyar lecture here at Shastra Deemed University on the development of jurisprudence after the A.K. Gopalan case.
Honorable Mr. Justice B.N.Srikrishna, who is presiding over the function today. Honorable Justice N. Santosh Hegde, former Judge of the Supreme Court of India, and Shri K.K. Venugopal, former Attorney General for India, who are guests of honor today. Shri C.S. Vaidyanathan, Senior Advocate. All the other distinguished members who are present today, the Vice Chancellor of the University, Mr. Ashish Bhargava, and everybody who is present today. I consider it as a great honor and privilege to be part of today's proceedings. As a young lawyer, I saw Justice Srikrishna when he was in the avatar as a lawyer in Bombay, a senior counsel practicing mainly on labor, industrial, and constitutional matters. I saw Justice Santosh Hegde in his avatar as lawyer, senior advocate here in Supreme Court. I had the privilege to assist him also in some matters on behalf of Union of India. Of course, great Venugopal, who hasn't assisted him. Everybody coming from Supreme Court at some stage or the other must have had some occasion to be part of any matter where Mr. Venugopal was briefed as a lawyer. I have great association with C.S. Vaidyanathan, who I've also appeared in many matters with him. So it's a galaxy of all these persons in front of whom who started as a junior counsel in this court, I consider it is my extreme privilege that I am now in the galaxy of these stalwarts. And talking about somebody who any youngster who joins the bar and who has something to do with the constitutional law of this country would always be guided by one single name to begin with, and that is M.K. Nambyar. I was junior in the chambers of Mr. Sorabji, and Mr. Sorabji was extremely proud of his work, which is Gopalan to Golaknath, case study and dealing with M.K. Nambyar's contributions. So when the occasion came, I thought this particular occasion would demand and would justify some contribution from my side as to how I have understood Gopalan and to what extent that the principles laid down in Gopalan, to what extent they have traveled and been part of our jurisprudence, our ethos. An author came out with a piece and he said that soon after the Supreme Court of India was established, within 2 months, 2 Nambyars entered the Supreme Court. One, Gopalan Nambyar, through the registry of the Supreme Court, and one M.K. Nambyar through the court halls of the Supreme Court. Gopalan Nambyar was detained under the Preventive Detention Act, and challenging his detention, which included even the challenge to the validity of the law, writ petition was filed in this court. And mind you, that writ petition was numbered as OP number 13 of 1950. Many research scholars keep thinking, what were those items, the numbers 1 to 12? Nobody knows, the history doesn't know what were those OPs 1 to 12. But OP 13 of 1950 has become immortal in our jurisprudential and constitutional history. M.K. Nambyar, who argued the matter and came out with such brilliant submissions that the bench of 6 judges, each one of them has quoted in extenso the submissions advanced by Mr. M.K. Nambyar. Every one of them has quoted those submissions. Out of those submissions, 3 principles which emerge are those which I will highlight and then travel from that level and bring about what exactly are the changes and to what extent those principles have been adopted in our jurisprudence. So to start with, the observations made by Chief Justice Kania, which set out the submissions made by Mr. Nambyar, and those submissions, just to understand and to draw the pitch so far as our today's discussion is concerned. The first submission which was noted was, it was argued that Articles 19 and 21 should be read together as implementing each other. Article 19 gave substantive rights to citizens, while Article 21 prescribed that no person can be deprived of his life and personal liberty except by procedure established by law. This submission of Mr. Nambyar that Articles 19 and 21 must be read together, that is, there is a common thread which runs through all the liberties which are enshrined in Part 3 of the Constitution, and they must be read together rather than disjunctively, is one principle which was the first submission which was advanced by Mr. Nambyar. Justice Patanjali Sastry then recorded one more submission of Mr. Nambyar. I am not repeating what the other judges have recorded. Justice Patanjali Sastry says, alternatively, the petitioner had a fundamental right under Article 21 not to be deprived of his personal liberty except according to procedure established by law and the impugned act by authorizing detention otherwise than in accordance with proper procedure took away that right and was therefore void. Now, not just procedure established by law, but that procedure must be a proper procedure. This is the second submission which was advanced by Mr. Nambyar. So one school of thought was that procedure established by law, which finds an expression which finds presence in Article 21, if the law were to prescribe a particular procedure, would that be an answer to any challenge that the law has prescribed the procedure? And so therefore, that's the end of the matter. So he went a step further and said that that procedure must be a proper procedure. So therefore, that's the second submission of Mr. Nambyar, which got recorded. The third submission, which again Justice Patanjali Sastry records, and that submission was, Mr. Nambyar urged that the word law in Article 21 should be understood not in the sense of an enactment, but as signifying the immutable and universal principles of natural justice, the just natural of the civil law, and that the expression procedure established by law meant the same thing as that famous phrase due process of law in the American Constitution in its procedural aspect. Now, this was the third submission, which was that the law must be understood not in the sense of an enactment, but signifying immutable and universal principles of natural justice. So therefore, that must also be included when you construe law which finds expression mentioned in Article 21. Now, these were three primary submissions which Mr. Nambyar advanced. 6 judges, they formed the bench, except Justice Fazal Ali, who was the lone dissenting note. All other 5 judges did not approve, did not accept the submissions advanced by Mr. Nambyar. Now, every one of them has noted all these submissions in such extenso and with such appreciation and awe, which is actually evident in the fact they copiously note everything. Every submission has been noted with great respect. Of course, they did not agree, 5 judges, but the lone dissenting note, which then became one of the classic dissents in the history of Indian jurisprudence, and that is Justice Fazal Ali's note. Before I turn to Fazal Ali, there are certain things which Justice B.K. Mukherjee said and which is worth noting. And this is how he notes the submissions, because his felicity of expression is something which is noteworthy. So therefore, pardon me for that, if I may just place that. Justice B.K. Mukherjee said, the contentions that have been put forward by Mr. Nambyar, who appeared in support of the petition, may be classified under 4 heads. His first contention is that as preventive detention is, in substance, a restriction on free movements of a person throughout the Indian territory, it comes within the purview of Article 19(1)(d) of Part 3 of the Constitution, which lays down the fundamental rights. Under Clause 5 of the article, any restriction imposed upon this right of free movement must be reasonable and should be prescribed in the interest of the general public. Again, the same thing, that they should not be construed disjunctively. Article 19(1)(d) must also be read along with Article 21 to the extent it impinges upon the right of a détenu under 19(1)(d). So therefore, the matter needs to be construed from both perspectives. So this was the first submission which gets recorded. The question as to whether it is reasonable or not is a justifiable matter which is to be determined by the court. This being the legal position, the Learned Counsel invites us to hold that the main provisions of the Impugned Act, particularly those which are contained in sections 3, 7, 10, 11, 12, 13, 14, are wholly reasonable and should be invalidated on that ground. This was, of course, the challenge to the law. The second contention advanced by the Learned Counsel is that the impugned legislation is in conflict with the provisions of Article 21, inasmuch as it provides for deprivation of the personal liberty of a man, not in accordance with the procedure established by law, It is argued that law here does not mean or refer to any particular legislative enactment, but it means the general law of the land embodying those principles of natural justice with regard to procedure which are regarded as fundamental in all systems of civilized jurisprudence. So this is one of those three principles which I said. So therefore, one has to see the matter, Gopalan, from the standpoint of these three principles, which unfortunately did not receive acceptance from the majority, but subsequently have become now the ethos of our jurisprudence. Then Justice Sudhir Ranjan Das, very prettily in just 3 sentences, he says, the claim of learned counsel for the petitioner is that Article 21 prescribes a procedure. This procedure, according to the learned counsel, means those fundamental immutable rules of procedure which are sanctioned or well established by principles of natural justice, acceptance in all countries and at all times. Now, this is where Gopalan stood. Gopalan stood the ground till R.C. Cooper was delivered by a bench of 11 judges of this court. Now, the theory that the articles of the Constitution which embody guarantees of fundamental rights under Part 3 must be construed, or the theory that every article is a class by itself or is a compartment by itself, and there can't be any overlapping, or you can't read both the articles or 3 articles together, that the theory of disjunctive interpretation was given a complete go by in R.C. Cooper. Now, R.C. Cooper, which was a judgment delivered by J.C. Shah, but before that, I must say that what was the dissent of Fazl Ali, because Fazl Ali accepts everything what Mr. Nambyar said. And one of his passages from the note of Fazl Ali is very, very interesting. And what he says is, in a number of cases, it has been held that though there may be no specific provision for notice, the provision must be read in the statute. I am aware that some judges have expressed strong dislike for the expression natural justice on the ground that it is too vague and elastic, but where there are well-known principles with no vagueness about them, which all systems of law have respected and recognized, they cannot be discarded merely because they are in the ultimate analysis found to be based on natural justice. That the expression natural justice is not unknown to our law is apparent from the fact that Privy Council has in many criminal appeals from this country laid down that it shall exercise its power of interference with the course of criminal justice in this country when there has been a breach of principles of natural justice or departure from the requirements of justice. So Justice Fazl Ali accepts whatever Mr. Nambyar propounded. It is in this theory, which is 5:1, that the matter was then considered in R.C. Cooper. R.C. Cooper has a very short passage which deals with this, and the passage then says, Justice J.C. Shah speaking for the court, the enunciation of rights, either express or by implication, does not follow a uniform pattern, but one thread runs through them. They seek to protect the rights of the individual or groups of individuals against infringement of those rights within specific limits. Part 3 of the Constitution weaves a pattern of guarantees on the texture of basic human rights. The guarantees delimit the protection of those rights in their allotted fields. They do not attempt to enunciate distinct rights. Now that's where we stand right after Gopalan up to what we say R.C. Cooper. Then the celebrated case in Maneka Gandhi, where all these 3 principles now have been brought to the fore. Justice Bhagwati, speaking for the court, then says, I'll rather quote this Bhagavati's passage from the subsequent judgments, which are in Puttaswamy and everything, because that's where the journey has finally sort of, reached the destination. So, Justice Bhagavati accepted that Gopalan was the correct law. Gopalan, the submissions of Nambyar were the correct way of understanding things. And the dissent of Justice Fazal Ali was actually the correct law. The minority view expressed by Justice Fazal Ali was accepted in Maneka Gandhi, and the majority view taken by the majority of the judges, the 5 judges in Gopalan, was not accepted to be the correct law. Now, the passage which comes subsequently in Puttaswamy, which is Dr. Justice Chandrachud speaking for the entire court, that delineates the travel from Gopalan right up to Maneka Gandhi and further down the line. And that passage is something which I will place before the entire audience so that the ground is made for the further deliberation. The passage goes like this. The abrogation of the Gopalan doctrine in R.C. Cooper versus Union of India was revisited in a 7-judge bench decision in Maneka. Justice P.N. Bhagavati, who delivered the leading opinion of 3 judges, held that the judgment in Cooper affirms the dissenting Cooper opinion of Sri Subbarao in Kharak Singh as expressed the valid constitutional position. Hence, in Maneka, the court held that it was in Kharak Singh versus State of UP that the question as to the proper scope and meaning of the expression personal liberty came up pointedly for consideration for the first time before this court. The majority of the judges took the view that personal liberty is used in the articles as a compendious term to include within itself all the varieties of rights which go to make up the personal liberties of a man other than those dealt with in the several clauses of Article 19.1. In other words, while Article 19.1 deals with particular species or attributes of that freedom, personal liberty in Article 21 takes in and comprises the residue. The minority judges, however, disagreed with this view taken by the majority and explained their position in the following words. No doubt, the expression personal liberty is a comprehensive one, and the right to move freely is an attribute of personal liberty. It is said that the freedom to move freely is carved out of personal liberty, and therefore the expression personal liberty in Article 21 excludes that attribute. In our view, this is not a correct approach. Both are independent fundamental rights, though there is overlapping. There is no question of one being carved out of another. The fundamental right of life and liberty has many attributes, and some of them are found in Article 19. If a person's fundamental right under 21 is infringed, the state can rely upon a law to sustain the action, but that cannot be a complete answer unless the state law satisfies the test laid down in Article 19.2 so far as the attributes covered by Article 19.1 are concerned, unquote. There can be no doubt that in view of the decision of this court in R.C. Cooper, the minority view must be regarded as correct and the majority view must be held to have been overruled. So therefore, this is the judicial exposition saying that the minority view expressed by Justice Fazal Ali was actually the correct one and accepted by the progeny. Following the decision in Maneka, the established constitutional doctrine is that the expression personal liberty in Article 21 covers a variety of rights, some of which Maneka have been raised to the status of distinct fundamental rights and given additional protection under 19. Consequently, in Satwan Sani, the right to travel abroad was held to be subsumed within Article 21, as a consequence of which any deprivation of that right would be only by a procedure established by law. Prior to the enactment of the Passports Act, there was no law regulating the right to travel abroad, as a result of which the order of the passport officer refusing a passport was held to be invalid. The decision in Maneka carried the constitutional principle of the overlapping nature of fundamental rights to its logical conclusion. Now that's where I say. So therefore, the first submission advanced by Mr. Nambyar that there can be overlapping. You can't consider the rights which are under Part 3 disjunctively, not compartmentalization. There can be common thread which runs through these rights, and there can be overlapping of these rights. While construing a procedure established by law, one can look at the other articles. And while considering right under 19, one must go by, if there is any restriction, that restriction must also be procedure established by law and a proper procedure. So therefore, this constitutional ethos or the principle that we have adopted all through is actually the idea which was planted by Mr. Nambyar. The seed was planted in Gopalan. Of course, he did not succeed in that Gopalan matter, but the seed that was planted today has become now the accepted notion. It is part of our constitutional ethos. Similarly, the level at which we give precedence and preeminence to principles of natural justice, as those principles embody the basic principles of human existence, is also something which has been accepted as a notion in law. So therefore, the third principle advanced by Mr. Nambyar was also something which is now part of our constitutional history and jurisprudence. The second principle, of course, goes along with the first one, that once you say that there is no compartmentalization, then that procedure established by law, that must also be fair procedure, is something which Maneka Gandhi has handed it down in that celebrated piece. Therefore, this journey from Gopalan right up to Puttaswamy, yes, initially there were hurdles. Mr. Nambyar had to face that hurdle, 5:1, but the celebrated dissent, which was noted by Justice Fazal Ali and Nambyar's ideas, 3 principles which he propagated, have now been accepted all through. Now, one of the ideas which was touched upon by the previous speakers about contributions of Mr. Nambyar from Gopalan to Golaknath. Now, one principle which got advocated in Golaknath about the basic structure doctrine, I must share with the audience my recent visit to Germany. I had the occasion to meet the Chief Justice of the Constitutional Court. And if one studies Golaknath, the basic ideas have come from a German author. So those judges in Germany are very, very interested in noting that what was propounded by somebody in Germany has been accepted to be a basic feature of the Constitution. That principle has been accepted in our constitutional law, so much so that we have up till now set aside few amendments to the Constitution on the ground of violation of basic feature, including National Judicial Appointment Commission or P. Sambamurthy, or many other cases where basic structure doctrine has been utilized to strike down even constitutional amendments. And that's the contribution which the idea was advocated for the first time in Golaknath, of course by none other than M.K. Nambyar. Now, coming back to the basic topic today, that Gopalan down the line, there's one interesting facet. See, this idea that the procedure must be fair, that the procedure must be established by law, has been carried to such levels by subsequent benches and decisions. Say, for instance, Bachan Singh. Now, Bachan Singh, the issue came up was whether the death sentence, the award of death sentence could be constitutionally valid or not. And while dealing with that issue, Justice Sarkaria, who was the author of majority view, of course, Justice Bhagwati dissenting, but Justice Sarkaria in 2 passages has again quoted the law development from Gopalan down the line. And that I must place it for everybody's consumption. What Justice Sarkaria says in Bachan Singh is, in Maneka Gandhi, which was a decision by a bench of 7 judges, it was held by Bhagwati in his concurring judgment that the expression personal liberty in Article 21 is of the widest amplitude and it covers a variety of rights which go to constitute the personal liberty of man, and some of them have been raised to the status of distinct fundamental rights under Article 19. It was further observed that Articles 14, 19, and 21 are not to be interpreted in watertight compartments. Again, the same thought which was initially expressed by Mr. Nambyar. And consequently, a law depriving a person of personal liberty and prescribing a procedure for the purposes within the meaning of Article 91 has to stand the test of one or more of the fundamental rights conferred under Article 19, which may be applicable in a given situation. Ex hypothesi, it must also be liable to be tested with reference to Article 14. The principle of reasonableness pervades all these 3 articles, with the result that the procedure contemplated by Article 21 must be, quote unquote, right and just and fair, unquote, and not arbitrary, fanciful, or oppressive. Otherwise, it should be no procedure at all, and the requirements of Article 21 would not be satisfied. This is again one of the same idea which was advocated by Mr. Nambyar, which has now gained acceptance all through. Then after quoting Article 21, Justice Sarkaria says, thus expanded and read for interpretative purposes, Article 21 clearly brings out the implication that the founding fathers recognized the right of the state to deprive a person of his life and liberty in accordance with fair, just, and reasonable procedure established by valid law. One more judgment, and that is that Mithu's judgment, because Mithu was again a case where Section 303 of the IPC prescribed death sentence in case a offense of murder was committed by somebody who was already undergoing life sentence for having committed an offense of murder earlier. So there the discretion was taken away from the judicial organ and the judiciary was obliged to grant death sentence. The validity of that provision was again tested on the ground that whether the procedure established by law is fair and just or not. And that's where Justice Chandrachud then, speaking for the bench, says, again goes to Maneka Gandhi, Sunil Batra, and the observations of some of the earlier judges. In Maneka Gandhi versus Union of India, it was held by a 7-judge bench that a statute which merely prescribed some kind of procedure for depriving a person of his life or liberty cannot ever meet the requirements of Article 21. The procedure prescribed by law has to be fair, just, and reasonable, not fanciful, oppressive, or arbitrary. Justice Bhagwati observed, principally the concept of reasonableness must be projected in the procedure contemplated by Article 21, having regard to the impact of Article 14 on that article, unquote. In Sunil Batra, while dealing with the question as to whether a person awaiting death sentence can be kept in solitary confinement, Justice Krishnaiyer said that though our constitution did not have a due process clause as in the American Constitution, the same consequence ensued after the decision in the bank nationalization, that is R.C. Cooper. Again, we go back to the same source. Every time, whatever developments are in the field of law, they trace their origin to Gopalan first, and then acceptance of the Gopalan principle in Cooper and Maneka Gandhi. For what is punitively outrageous, scandalizingly unusual or cruel, and rehabilitatively counterproductive is unarguably unreasonable and arbitrary, and is shot down by Articles 14 and 19, and if inflicted with procedural unfairness, falls foul of Article 21. Then Justice Chandrachud quotes what Justice Desai observed in Sunil Batra. The observations go like this. The word law in the expression procedure established by law in Article 21 has been interpreted to mean, in Maneka Gandhi's case, that the law must be right, just, and fair, and not arbitrary, fanciful, or oppressive. Otherwise, it would be no procedure at all, and the requirement of Article 21 would not be satisfied. If it is arbitrary, it would be violative of Article 14. Relying on this development, Justice Chandrachud then goes on to say that section 303 textually though may say that death sentence shall be granted, yet by interpretative process, the provision was interpreted to say that the concerned judicial officer still had the discretion not to grant death sentence. Why? Because the procedure must be completely fair. The discretion must be with the judicial organ. It is this logic, these developments, these three principles which have gained acceptance over a period of time, right from 1950 when it was advocated for the first time. And that's exactly, one must see what were the observations of the then Attorney General. Everybody was in awe and appreciation of the efforts put in by Mr. Nambyar. And the observations made by Attorney General in one of his books is, he says in his book, which is My Life, Law and Other Things, M.C. Settleward wrote, the petitioner was represented by M.K. Nambyar, who in presenting his first argument in the Supreme Court, showed himself to be an able constitutional lawyer. That was the first case which was argued before a constitution bench. And to come out with theories, which theories though did not receive acceptance immediately, but those theories were such fundamental and basic ideas that those seeds which were planted by Mr. Nambyar have now actually resulted in such a huge banyan tree that under that particular tree, in the shadow of that tree, every citizen can have solace and say with thanks that very well, Mr. Nambyar, it's for your efforts that the constitutional history has brought us here. Thank you so much. Thank you.
Judicial wisdom was seen in its finest flashes of intellectual intensity and variety in your Lordship's address. This address will be remembered for long and cherished by us, my Lord. Your Lordship's thrust in the very beginnings of the A.K. Gopalan case, the exhaustive textual analysis of the judgments by each honorable judge, Justice Fasil Ali being a prophet of honor, and a distillation of constitutional principles have left a deep mark in all of our minds. India's inspiring constitutional voyage, captured in its presidential profusion by your Lordship, made for this great evening. The long winding road, starting with the A.K. Gopalan case and ending in the K.S. Puttaswamy judgment, was delineated in this master class by your Lordship. Thank you, your Lordship. May I request Sri C.S. Vaidyanathan, Senior Advocate, to deliver his closing remarks.
The Honorable Chief Justice, Justice U.U.Lalit, Justice Srikrishna, Justice Santosh Hegde, my revered and respected senior Mr. Venugopal, Dr. Vaidya Subramaniam, Dr. Mr. Amrit Bhargava, Shivasri, Skanda Prasad, and all those who are watching the proceedings. There is a common trait amongst all those who have spoken today. And I have to mention that they have all, during their tenure holding certain offices, constitutional offices, put the institution above self. Each one of the persons who have addressed, they have put nation before self. All constitutional office holders and public office holders should follow that ideal. After such a erudite lecture, there is not much for me to say. Even now, when I read Gopalan, and I do that quite often, or Sajjan Singh, the vision and foresight of Mr. Nambyar is writ large. He's wide and expansive, and at the same time, intensive study of the constitutions of the world had given Mr. Nambyar deep insights, including the need not to treat each of the fundamental rights in silos. And that is what the Chief Justice was pointing out. The silo approach, which was laid down by the majority, was given up subsequently. And he wanted them to be read harmoniously, which later gained acceptance. His second emphasis on just, fair, and reasonable procedure found acceptance as far back as in BD Supply Company by Justice Bose and thereafter. Of course, Menaka Gandhi is put its final stamp of approval, and the silo theory was laid to rest in Cooper. Sajjan Singh it was where Justice Budolkar actually recorded the theory of implied limitations, which was first propounded by Mr. Nambyar, which gained acceptance subsequently in Keshav Bharti. Because Golaknath, they went on whether constitutional amendment is law. They didn't go into the question of implied limitations. But Sajjan Singh's seat was accepted in Keshav Bharti, and fortunately, as Mr. Justice Srikrishna mentioned, that has survived till date, and hopefully our democracy and republic will maintain the tradition. In fact, Mr. Nambyar saw his ideas, which he planted in Gopalan and subsequently come to fruition during his lifetime before he passed away in 1975. I don't want to, again, extensively go through all this, but there's one last point which I want to mention. And it's very important from the point of view of what is sacred, what was sacred to Mr. Nambyar, what has been sacred to all of us, the independence of the institution of judiciary. There are whispers in the air, and I hope they are not true, of the collegium thinking that they will send recommendations only if they are going to be accepted by the government. This, I think, is a very, very dangerous thought. I hope that this does not ever come to be true. Because if it is so, it necessarily means prior informal consultation. That would mean the very negation of the independence of judiciary and of the NJSC judgment, the very fundamental principles on which the NJSC judgment was given. I think if that is to be done, it is much better to review NJSC judgment by a larger bench and then have a formal process of consultation rather than having this introduced in this manner. That, because it is very, very topical, I thought I must mention the Honorable Chief Justice is here, and I'm very, very grateful to all the persons who have participated today, and I do not want to take more of your time of any one of us. I just want to end by thanking Dr. Vaidya Subramaniam for all the activities that have been undertaken in under the auspices of the chair. Thank you very much. Thank you all.
Thanks to everyone. Thank you.
Thank you, sir. Surely the office of Mr. M.K. Nambyar and Sri K.K. Venugopal is a beehive of constitutional law, inimitable and indelible, with the independence of judiciary, as Senior Advocate C.S. Vaidyanathan so rightly pointed out. being the first article of faith and the last facet of our constitutional creed. May I invite Rumana Kader, a fifth-year law student of Sastra Deemed University, Tanjavur, to propose the vote of thanks.
Thank you, sir. Good evening, everyone. It is my privilege to propose a vote of thanks for the second M.K. Nambyar Memorial Lecture on Development of Jurisprudence after Gopalan, organized by School of Law, Sastra Deemed University, under the aegis of the C.S. Vaidyanathan Chair on Law and Development. I humbly extend my warmest and heartfelt gratitude to today's very distinguished speaker, Honorable Mr. Justice U.U.Lalit, the Chief Justice of India, for imparting knowledge on the conjunctive reading of Articles 19 and 21 of the Indian Constitution. We are immensely grateful for the way you explained the demarcation marked by the late barrister Shri M.K. Nambyar between procedure established by law and proper procedure. Sir, thank you once again for gracing this memorial lecture with your thoughts on the development of jurisprudence after A.K. Gopalan was State of Madras. We are beyond grateful to the Honorable Justice B.N.Srikrishna, former Judge, Supreme Court of India, for making us understand the nuances involved in reading, writing, and arithmetics. Your take on right to education is inspiring, sir. Our hearts are filled with respect and admiration for our guests of honor, Shri K.K. Venugopal, Senior Advocate and former Attorney General for India, and Honorable Mr. Justice N. Santosh Hegde, former Judge, Supreme Court of India, for sharing their wisdom on the importance of comparative constitutionalism as it was practiced by the late barrister Shri M.K. Nambyar. We are tremendously thankful to Shri C.S. Vaidyanathan, Senior Advocate and former Additional Solicitor General of India, for his closing remarks on the independence of the judiciary. We cannot thank you enough for establishing the chair on law and development, sir. Further, I take this opportunity to offer my sincere gratitude to the university leadership, the organizing committee, and of course the audience for making the second M.K. Nambyar Memorial Lecture a grand success. I, being a law student, take the moment to be thankful to the university for making me a part of today's session. Thank you everyone for being with us this evening. It was an absolute pleasure to host you all. Thank you.
Thank you.
Thank you very much, sir.
Thank you.